Welcome to the program. I'm Mark Imperial. This segment's being brought to you by booksgrowbusiness.com. It's the place where busy professionals and entrepreneurs publish to grow their practices, to inform their consumers, and to leave a legacy. We're doing a series of spotlights on remarkable attorneys with focuses on elder law and estate planning. Joining me on this segment, representing Rhode Island, Massachusetts, and Connecticut, is estate planning attorney Sheri Montecalvo with Estate Planning with Sheri Montecalvo. Sheri, welcome to the program.
Thank you. Thank you, Mark, for having me.
Now, I know estate planning and elder law is a broad topic. Please give us a glimpse into like your areas of focus on that spectrum, and specifically, who are the types of folks that you serve?
Yeah, so elder law, estate planning attorneys, we focus in the areas of estate planning, long-term care planning, disability planning, probate and trust administration. And our spectrum of clients really run from the young all the way up to the elderly, but I would say a major segment are middle-aged or 65 and over who are looking for, an eye towards estate planning, asset protection. So that's really what estate planning and elder law attorneys focus on.
I know that the pandemic has shined a huge spotlight on the gap of knowledge in this area. What have you heard lately? What are the biggest challenges that you're finding people in nowadays?
Well, with the pandemic, it really actually changed a lot of my clients and even other prospective clients, their mindset. They're finally realizing that I can be young and healthy and also, face something with a chance of a mortality. It puts it into the forefront of consideration. And with that, you really need to have your estate planning documents in order. So one of the major misconceptions is that people think that they're too young in order to do estate planning documents. You're never too young, because as the pandemic has showed us, you could come down with a sudden illness or an accident, and you need documents in order to protect you in the event of incapacitation or passing. So as far as the challenges, it was just in a way a slightly positive effect in this area, because it really brought the importance of estate planning and getting your affairs in order. Some of the negative sides of the pandemic, as far as probate administration, a lot of the courts are on half staff, so it kind of has slowed down an already slow process with respect to moving those probate estates along.
And that sounds like a very difficult situation to be in when you're already in that kind of emotional, point in your life, and then having courts delayed for perhaps years to facilitate that. So, Sheri, what are some of the dangers of not having your affairs in order, or if people avoid this and put their head in the sand and they don't take care of this earlier rather than later? What are some of the dangers?
Some of the dangers are that you're really leaving everything up to chance. And why wouldn't you want to, with your most, your family, your children, if you have minor children, why wouldn't you want to nominate a guardian for your children? Or if you have assets, why wouldn't you want to make sure that you devised your assets to the individuals that you wanted, how you wanted them to be bequeathed and devised? If you do nothing, one of the great phrases, if you fail to plan to fail, because at that point you're really leaving everything open. Procedures can take much longer. Other beneficiaries or interested parties can come in and have a say in the matter, where honestly you could set your intentions and put them down in writing, and then the will and the testamentary documents speak at the time of death. So those would be upheld with your written decision. So you could, let's just say if you didn't have a will, you would be in administration, and the assets would be devised according to the laws of intestacy of the domicile of the decedent. And it could be, left to a beneficiary that you didn't want to leave it to. And most importantly, with the guardian provisions, with the minors, you could have anyone petitioning the court for a guardianship of a minor child, where I believe most parents would want to have the opportunity to pick someone who they're confident in.
I think these days, I found that there's that lack of or under information about this area of elder law and estate planning. And the old fashioned way of thinking is sort of like, I've got a will. Isn't that enough? I think that's the what people just think that they need to have, and that's it. What is the danger of just having a will and that's it?
And that's an excellent point because that is one of the top misconceptions in estate planning is, oh, I just need a basic will. Well, in conjunction with that, you also need to prepare for the event of incapacitation. So we'd certainly want to add on a durable general power of attorney, which is a financial power of attorney, your healthcare power of attorney in the event that you became incapacitated, a HIPAA authorization form to allow access to the documents, all of those, so the basic will with the powers of attorney and HIPAA authorization, those should really be at a minimum your essential documents. And then other clients sometimes don't realize that another vehicle may be better for them. So a revocable inter vivos trust that becomes into existence now during the client's lifetime that will grow with them and grow with their assets. And they may feel as if, oh, well, that might be a little bit more financially than I want to commit to in, upfront in the beginning. But in the long run, it's saving you so much time and money on any type of probate fees, which can be very expensive and can also take a lengthy amount of time versus a trust administration. So that's something that I go over with all of my clients, that you may have come into this just thinking you only need a basic will, but let's look at the entire process and put all of your options out there so you can make an educated decision.
I also hear a lot of people say, oh, I don't need to plan for that yet. When is the right time? And now is it becoming more in vogue to do this earlier rather than later, like financial planning? Like, when is the right time for people to really start looking at their estate plan and their other elder law issues?
I would say as soon as you are old enough and you're an adult to draft your own will and your healthcare power of attorney and your financial power of attorney, that is the time. It's also a common misconception that someone has to have assets. You'd at least want to have those documents to take care of you in the event of incapacitation. And then, of course, once you ever have any type of what I call a material change, you're getting married, you're having children, you're getting a divorce, or you're coming into any type of inheritance. Any times like that, it's a good time to, of course, have an estate plan. And if you haven't done it, then have it done at that time, or make sure that you update it. So I always tell my clients within 3 to 5 years, I want to see you back. Most of my clients are very close with me, so they keep me updated. They shoot me emails as to the advancements that are going on in their lives. But if I don't hear from them, at a minimum every 3 to 5 years, and then of course, if there's any material changes.
Sheri, what inspired you to focus on estate planning and elder law? How did you get started?
It's always been a passion of mine. I like seeing and serving the generations. So to me, it's a wonderful experience and feeling to know that I helped mom and dad with their plan, and then they had enough confidence in me to recommend me to either their children or a friend or a family member. So I'm with them as a trusted advisor throughout the generations. So I get to have that close family relationship. They send me cards, thank you cards. They send me pictures of weddings that are happening in the family. So to me, it's always been very rewarding to take the client and make them have an estate plan that fits all of their goals and needs, and I can serve the family going on for generations.
How can listeners in my audience who are in the Rhode Island, Massachusetts, or Connecticut area, how can they connect with you and learn more?
Absolutely, Mark. So I have a Facebook page, Estate Planning with Sheri, and that's SHERI. I also have a website, www.estateplanningwithsheri.com. And I also have a direct line, 401-471-6034.
Sheri, this has been terrific. I really appreciate you taking the time out of your busy schedule to share with my audience today. I wish you continued success for you and for all of your clients.
Thank you, Mark, so much, and it was a pleasure. Thank you for selecting me for a spotlight.
Sheri Montecalvo, founder of Estate Planning with Sheri. And this segment's been brought to you by booksgrowbusiness.com. It's the place where busy professionals, entrepreneurs, and business owners publish to inform their consumers, grow their practices and their businesses, and to leave a legacy. That's all for now. I'm Mark Imperial, and thanks for joining me.